Good evening, ladies and gentlemen. Welcome to the Kingston Zoning Board of Adjustment hearing for December 9th, 2021. Got a couple board items of business, and one would be the acceptance of the minutes from November 10th, I believe it is.
Yeah, and I'll move that we accept the minutes from November 10th as written.
Okay, and is there a second? Any errors or omissions or corrections? Okay, all those in favor, please say aye.
Aye.
Opposed, no. We still have to wait 5 minutes because we can't start the first hearing at 7:05. Is there any other business before us? I'll tell the general public we're always looking for alternates to come join the board, see what it's like, perhaps even run for office come March. We're always looking for new representatives. I know the Board of Selectmen are looking for individuals to work on the solar panel committee as well as a landfill/recycling committee. We've had a number of responses from the public willing to serve, which is awesome. Probably have more people than we need, which is a really nice problem to have. For both committees, yeah, and it's really it's great how people have stepped to the plate on both issues.
Things the paper, the front page of the paper.
That helps, yeah. That helps. Oh my God, I hate it. Dead air, dead air.
Seems like a long time.
I know, it does, it does. I think we can invite the first petitioner to come forward. By the time we get settled and I start reading the legal notice, we definitely will meet the 7:05 requirement. You are welcome to take off your mask if you're comfortable enough to do so, not a problem. Again, your distance.
I might overcheat if I keep it on.
Whatever you're comfortable with, we're not suggesting anything. They're recommended and please identify yourselves for the record.
Hi, good evening, Madam Chair. My name is Justin Pesse. I'm a lawyer at DTC Lawyers in Portsmouth. I'm joined tonight by my clients, Leah Hearns, Jim, and Ida Hearns.
Welcome. Okay, I'm going to read the legal notice into the record. This is a continuation from November 10, 2021 of a public hearing whereby the applicant seeks an appeal from an administrative decision, a special exception, and 5 variances so that the applicants can demolish and rebuild their single-family home in approximately the same location. The applicants appeal the administrative decision regarding Article 301, Section 301D of the Town of Kingston zoning ordinance, whereby the building inspector denied the building permit. Furthermore, the applicants seek a special exception to the terms of Article 205, Section 205-7 of the Town of Kingston Shoreline Protection District zoning ordinance to permit the construction of a 1,540 square foot single-family residence in the same approximate footprint as the existing residence and installing a new septic tank and leach field. In addition, the applicants seek the following variances: Article 202, Section 202-5B, Article 205, Section 205-4C, to permit construction of a 1,540 square foot single-family residence in the same approximate footprint as the existing residence and installing a new septic tank and leach field. Article 301, Section 301-1D, to permit the improvement and/or placement of a single-family dwelling structure located within 20 feet from the front property line, and to permit the improvement and/or placement of a staircase located within 20 feet from the front property line, and to permit the improvement and/or placement of a deck located within 20 feet from the front property line. I think we had covered everything in the legal notices, and I thank you and your company for clearly delineating that so that we didn't leave any stone unturned.
Sure, I'm happy to.
Our procedure is to allow you, we've received your packet of material, it's been distributed to the board members. They had it at the November meeting, which we ended up continuing to hear. So we've had the material, but you're welcome to give a general overview of your position and why. We will open it up to the public for comments or questions, both in support of your petition or in opposition, and then we'll open it up to the board. And before we go any further, I should introduce my colleagues to you. To my far right is Jackie Leone and Peter Coffin, our vice chair Larry Greenbaum. My far left is Richard Johnson, and to my immediate left is Susan Ayer, our secretary, and I'm Ellie Alessio, your chairman. So,
Thank you.
Mr. Pesci, would you like to begin?
Yes, please. So first I wanted to say thank you. Thank you to this board. You entertained and approved a last-minute continuance request for us in November. I was sick. Thought I could force myself to come here, but as the day went on, I got worse, and it was just more practical to continue. So thank you for that.
No
And thank you to Mr. Seward, too. I know he's not here, but throughout this process, the last couple of months, I've been on the phone with him quite a bit, and we've talked a lot, and it's been very congenial, and I appreciate his time and his work and effort on this matter. So I just wanted to start with that. The way that we've set this up, we've asked for relief in the alternative. So the first thing that we did was request a building permit to accomplish the raising of the Ahern's existing building, their house on their property, and to replace it with a new structure. And we outlined in our analysis to Mr. Seward why we thought under the law, the state constitution, the state statutes, the town zoning ordinance, why they were entitled to do that without variance relief. And we asked that if he disagreed, he write us a letter and explain why and deny that request, which he did, and which is in the package. So the first form of relief that we've sought tonight is an appeal of that decision, which comes to the ZBA under the state statute and under the town zoning ordinance. So I think it makes the most sense to talk about that one first, just to explain our position, and if it pleases the board, have the board make a decision on that, because if the board agrees with our perspective on that, then I don't think any additional relief is required, and I think the hearing will be over from our perspective, subject to the thoughts from the board. So that was our proposal, just as a way to sequence the relief that we've sought in a manner that makes sense.
Well, I don't know how my colleagues feel, but I am under the impression that we're going to take action in all three to clearly delineate our position on whether, regardless of what the perspective is. Again, I don't know what my colleagues want to do with that.
I guess that's the first question, because that's the third variance is the same article as the denial, and so if we hear the denial,
You mean Article 301, is that the one you're referring to, Peter?
301, point D.
1D, yeah.
Yeah, and that's the, Article 301, Section D is that presumably the variance wouldn't be required if we said that Robert made a mistake in denying it because it needed variance. He basically, in his letter, he said that, that they can't do that without variance because it's, I don't know exactly.
Well,
but-
yeah, the first one is the appeal the administrative decision regarding Article 301, 301D, whereby the building inspector denied the building permit.
Right, so if we say that that was an error, then there's
Then you
no
s-
requirement.
Then
to
you
grant
say the
variance.
rest of them are moot.
Well, I'm not sure about the other ones, because I think we'd have to hear about the other ones, because those weren't mentioned in the letter. The denial was just, we're just hearing about 301D on the denial. So, actually, I only counted 3 variances, an appeal, a special exception, and 3 variances. You've got 5 variances listed?
Right, so the sort of at bottom, our position is that on the law of New Hampshire, based on the Constitution and the case law as we've outlined, no variance relief is required from the zoning ordinance. So that was the position that we outlined to Mr. Seward. And he responded and said, I disagree, and here are the 3 variances that you need. And they were all variances from 301D. So when we looked at the zoning ordinance though, and tried to be as precautionary as we could, we said, well, technically then, if we have to get variance relief, if the ZBA does not agree with our position about whether we need it at all, then we probably need variance relief from these 2 other provisions as well, one related to the Wetland Conservation District, the other pertained to the Shoreline Protection District. So we added those on, and frankly, Mr. Seward called me before he had reviewed my package and said, oh, I think you might need this additional relief, and I said, yeah, well, we asked for that in our filing, and he expressed, thanks for having included that additional relief. But at bottom, if this board agrees with us that on the Constitution of New Hampshire and that on the law in New Hampshire, no variance relief is required because of what is being proposed, then I don't think any variance relief would be necessary to have to be taken up today.
Can you go through and explain how you came to that conclusion?
Yes, very happy to. Should I do that? The other thing I was going to suggest is that for all of our applications, the same base, foundational facts apply. So I was just going to give an overview of the property, it's the situation, what's being proposed, and that will apply to all of it. If this board denies our appeal and we have to go to the variances, then we'll just incorporate everything we already said and we can just go right to the variance relief, which
Okay.
should be quicker for everybody.
Okay.
Okay, perfect. So we're talking about 2 3rd Street here. It's right on the lake. It's map U4 lot 141. It's a very small parcel, just under 13,000 square feet total. Right now, it's in the single-family residential zone. It's also in the Wetlands Conservation District. It's also in the Shoreline Protection District, all because of its proximity to the lake. There's a single-family house on it right now that was constructed about 1950. It's got 2 bedrooms and a bath, and its construction predates the zoning in town, which is 1979. So the Ahern's proposal is to take that building down, and in its place, they propose to construct a new building. And that new building will comply with the town's zoning ordinances in a manner that is more conforming than what's there now. So the proposal is going to be better in all relevant respects for this board's consideration than what is there right now. And I just want to talk a little bit about specifically what I'm saying. So where our proposal, the new building, conflicts with the zoning ordinance, it is entirely dimensional in nature, okay? Section 301(1)D, which is what Mr. Seward pointed out to us, imposes a 20-foot front yard setback and a 20-foot rear side yard setback. Here, as depicted in our plans, and probably the easiest plans to look at are these big plans that say pre and post. And I'll give the board a second to take a look if they can locate that in the package. I think we printed it on 11/17.
You did, yes.
So, to just summarize specifically, the specific nonconformities that exist today and that we're opposing, I would just point us to these 2 plans, and we'll start with the pre-building setback. And you can see, just to orient everybody, to the sort of plan right is Great Pond, is the lake. You can see the structure situated on the parcel, and then on the top of the plan is 3rd Street. That's the access to the building. So that is what we are considering the front lot line. You can see in this pre-building setback that the closest structure on the property to the front line setback is 9.8 feet. Those are the steps going onto the deck. The dwelling itself is 11, at its closest to the front line, is 11.35. So,
I'm sorry.
Sure.
That Third Street is the front of the property.
Right.
Okay, perfect, thank you.
no problem. So, the closest any structure is to the front lot line is 9.8, those are the steps, but the house itself, the dwelling, is 11.35 feet from the front lot line, okay? So that's the first point, that's what's there right now. Looking at the proximity to the water, just look to plan right, you can see that the steps, the end of the steps are 25 feet to the top of the bank, which is where you measure the reference line from the water. The structure, the house, is 32 feet from the water, okay? So that is, again, that's what's there right now. If you go to the next page, you're looking at the post-building setback proposal. So you can see that on this one, again, we'll start with the front lot line. The closest that the steps come are 13.7 feet, okay? So it's about 5 feet further away from the front lot line than what's there right now. And the same basic dimensional component is the same with regards to the proposed new dwelling. You can see that the proposed new dwelling is 16.6 feet away from the front lot line, where right now it's 11.35. So again, about 5 feet further away from the front lot line is where the new house is proposed to be. While we're looking at this plan, and I know I've told you already, it's a little under 13,000 square feet, the whole property. This, you can see the setback requirements of the property depicted, and this is the setback requirements from 301D. 20 feet from the side and rear, and 20 feet from the front. So that's what's depicted there. And you can see that right now, the existing structure is sort of pushed towards the front lot line, and as proposed, the new structure is basically within that envelope of buildable area under 301D, and that's depicted on the post-building setback. So the proposal, and then turning to the lake, you can see that as proposed, the steps would be 34 feet, where 25 feet is the number today, and the house itself would be 37 feet away from the water, where 32 feet is existing today. So again, it's pulled about 5 feet away from the front lot line and 5 feet away from the lake. And this point is critical, because the only way that the town zoning ordinance is regulating this use on this property, and the only reason why we need zoning relief is because of the building's proximity to the front lot line and the building's proximity to the lake. So I'll say it now, I'll say it 100 times tonight. The proposal is going to be much better when it pertains to the things that the town cares about, the proximity of the structure to the front and the lake, than what exists today. And that's a very important point. It relates to the constitutional arguments that we're making, and I'll elaborate on this, but I wanted to just point that out. So the subtext of this is that if this proposal is approved by the board, the Aherns need state relief. And they need state relief because the property is within the entirety of the state shoreline protection district, just like it's within the town's shoreline protection district. The town defines the shoreline protection district as being 300 feet up off of the water, okay? So that's the entire property. All of the property is inside the town's shoreline protection district. The same is true with regards to the state's definition. The state has a 250-foot shoreline protection district, and you can see on this, there are other plans. I've included Peter Landry's state shoreline protection permit plan, and that's on 1117 as well, but you can see on that line that the entirety of the lot is within the 250 feet. Most of it is within 150 feet from the water. So if they get approval, they've got to get a shoreline protection permit from the state, and they've got to get septic approval. Septic is another really important thing for the board's consideration. Right now, they've got a system that's about 40 years old. It's located on the side of the house, close to the water. That's just the nature of what's there right now. What's being proposed as depicted on the plans that Peter Landry put together is really a state-of-the-art septic system, which is going to be further away from the water than what exists today. In fact, much further, almost at the back of the lot is where the new septic system will be. That's another really critical point for the board's consideration. Peter's plan talks a little bit about the impervious surface of the existing conditions and the impervious surface of what will be proposed. And we don't need to get into the weeds because the town doesn't regulate that, but I'll just say, there's about a 3% increase in the impervious surface of the lot area. But the lot itself, in the context of impervious surfaces, still remains compliant with the town's regulations, which in the Aquifer Protection District basically says 15% is the cutoff for impervious surface in the Aquifer Protection District. So the property will remain in compliance with that provision, and there'll be about a 3% increase in impervious surface. But everything is being pulled further away from the water and further away from the front setback, which again, that is the criteria that the town is most concerned about in its zoning regulations. So those are the baseline facts, I think, of what we've talked about and what the important critical things are for this board to consider on the facts. Our argument about the applicability of the zoning ordinance to this case is really rooted in the state constitution, and it's really rooted in the state case law. And as a foundational matter, the Supreme Court in New Hampshire has taken a very deferential look to real property rights. And I would say that the state of the law in New Hampshire, when it comes to the expansion of non-conforming uses, because that's really what we're talking about here. The whole lot is non-conforming. It's too small, the structure's non-conforming because it's too close to the front setback, it's too close to the water. But the state of the law in New Hampshire, which is really based on constitutional considerations, the rights to use real property that are protected by the statutes and the law in New Hampshire, the foundational conclusion is that as long as you are not making the non-conforming element more non-conforming, as long as you're not expanding your structure in a way that's going to be closer to the front yard in this case, or closer to the water, then the Supreme Court has said you don't need variance use because you are making a product that is going to be in closer conformity with the zoning ordinance than what exists today. And why is that a good public policy reason to have a property that is better conforming with the zoning ordinance in town than what exists? And that is the foundational baseline conclusion. We cite a lot of law. It's not my intention here to cite verse and chapter from the statutes, but I do want to talk about one case because it's really important. And it's a case out of Seabrook. And in that case, there was a house in a zoning district that only allowed 2-family houses. This house had 3 dwelling units on the property. So it was non-conforming because it had 3 where only 2 were allowed. The lot was also too small, just like the lot here. And the structure on that property was too close to it was in the setbacks. The owner of that property decided that they were going to finish a carport area. It was already part of the structure, but it was an unlivable carport area. And the owner said, I'm going to put walls on this, I'm going to make it a storage facility for the people that live in this house. The town said, you can't do that because you're expanding a non-conforming use. Of course, the owner challenged that and it went to the Supreme Court. And the Supreme Court said, wait a second, they're not expanding the portions of this structure that are non-conforming. They're not pushing this building further into the setback. They're not making more dwelling units on the property. They are proposing a change to the property that will be in conformance with the zoning ordinance. And the reason that's important is because it's the exact same thing that's happening in this case, okay? All of our nonconformity relates to dimensional requirements. Again, we're too close to the front lot line, we're too close to the water by the town's regulations. And what we're proposing otherwise complies with the zoning ordinance. It's a use that's permitted, it's a single family use, and it's making the structure more conforming. It's gonna be better when it comes to the terms of the zoning ordinance than what exists today. So that's the foundational point. Again, I elaborate in greater detail in the filing itself, but it comes really down to common sense. That part of the law makes sense because we want to encourage people to use their property, and we certainly want to permit people to use their property in a way that is in better compliance with the zoning ordinance than what exists today. Mr. Seward's respectful response was that he disagreed, and he said you need variance relief because what you're depicting is inside the setback. I've made our argument clear to the board on that point. That issue, from my perspective, is irrelevant. The issue is that we are making it better, and we otherwise comply with the zoning ordinance. And by New Hampshire law, I think that requires a finding that no variance relief is required. Certainly, we need to go to the state, we need septic relief, and we need shoreline permit relief. But no variance relief should be required under the statutes, under the case law, and under the zoning ordinance. So that's the summary of the argument. I recognize that that's a lot. I appreciate that the board has probably spent time reading the application as well. But if the board wants to take action on that matter, that will really dictate whether we go talk about the variances and the special exception or not.
Okay, before I open it up to the board, is there anyone in the audience that would like to speak in support or opposition to the request for an appeal of the administrative decision? Okay. Turn to my colleagues. Mr. Greenbaum.
Thank you. In my conversations with the building inspector, Mr. Stewart, his statement to me was, when you remove the existing building, now there is nothing. And you're starting over, and you have a non-conforming structure that you want to erect. It's not just, as you said in Seabrook, where they were adding or taking a portion and enclosing. You're removing it. And his opinion is that by removing it, you lose any privileges that that building had, for the terminology I'm using. And he said, so you're starting over, starting new, with new construction. What I've been trying to figure out is, how big a unit are you talking about putting in there? There are all kinds of drawings with yard setbacks, variances may be required, but there's nothing telling me, maybe I didn't see it, what size the building is to start with. How high is the building? Because that comes into consideration of the people behind it. You know, we've had cases like that. So, I don't know. I saw a sketch from a modular company who was just a picture of a building. It had no dimensions, nothing on it. So, I don't know what you want to put there, which is part of what I have to consider when I look at what you're asking for.
Sure. So I see two things in that comment, which I appreciate the comments you bring about. The first question I think you had was Mr. Stewart's point, which is, well, you're removing something, so you're starting at the bottom. And my respectful response to that is that position is not supported in the law. Okay, this is the state Supreme Court focuses on the use. You are entitled to continue to use your property in a way that's consistent with the zoning ordinance. So the use of this property is a single-family residential use. That use is continuing. That use is not being discontinued or abandoned or stopped. It's just that there's a proposal to take the building down and to replace it with, again, something that's much better in the eyes of the zoning ordinance than what's there today.
I understand that, and I'll tell you that from my personal knowledge, not necessarily in this town or this state, if you remove a building that's non-conforming and you want to put up a new building, you're starting over. And what he is saying to me makes sense because I've seen it happen in other areas. Now you're telling me the state law changes that and I'm sure you have citations in here, but I'm as far away from a lawyer as you can get. Well, maybe not.
About 20 feet. Look, I appreciate your position, and I do not question at all that this interpretation is an interpretation that takes place around the state. I don't question that at all. I'm sure it does. But I'm suggesting that the court has focused on the use. They're not saying we're going to focus on the building. Is that gone or not gone? Because it leads to this ridiculous interpretation, which I also know existed in New Hampshire in the past. If you just take down everything, but you leave one tiny little corner of it, It's a tortured analysis, right? It doesn't make sense when you consider the bigger picture, and the bigger picture is, don't we want to encourage people to use their property the way they want to, in a way that's consistent with the way the property's been used for 70 years? And don't we want to encourage uses of property that better conform to the zoning ordinance than what's there now? I think the answer to all those things are yes, and that's why this old analysis of, well, if you take it down, then you're technically starting over, it's not practical and it's not rooted in common sense for those reasons. I mean, I think that's why, because we want to encourage people to use their property in a way that's better for the public, better for the environment, better for the town, obviously better for the applicants.
Are you taking the whole house down to the foundation?
Yes.
That is the rub.
Now, how big a house are you putting up?
So right now on the site, total, well, the impervious, they measure it basically from the roof line, right? So the roof line right now is 1,031 square feet. Okay, the roof line proposed is 1,500. So it's an increase of about 500 square feet of impervious for the house, but the total increase of impervious surface on the lot is only 300 because they're removing things like the shed and portions of the walkway. So the footprint of the house gets a third bigger, but the impervious footprint across the whole lot only goes up 300 square feet from the way it is today to what it will be after proposal. And again, from the town's perspective, when it comes to impervious surfaces, it is compliant with what the town requires. So that's not something that's measured in the ordinances we're talking about. In the ordinances we're talking about, it is straightforward. It relates to dimensional qualities. How far is the building from the water? How far is it from the front lot line? But I referenced that just to give you a scope for the scale. We're still, at the end of the day, we're talking about a tiny lot that is 13,000 square feet in size that still only has 15% of impervious surface on it.
Mr. Passay, we deal with non-complying lots all the time, and
Sure.
I've been on this board for more than 20 years, and trust me, this is not unusual. What is unusual is most of your argument so far has been on the use of the building. We recognize that you're not changing the use, and I don't think that's an issue at all. The issue is, we're saying in effect, or Mr. Stewart is saying in effect, that you no longer have a grandfathered footprint into that house. If you had, let's say that the Hearns had wanted to raise the second floor and put a couple bedrooms on the second floor, but the main footprint stayed the same. And let's say they took part of the first floor footprint and reduced it a little bit. That would make it less non-conforming. And on those arguments, you are, I think, right on the money. And we always look to see a piece of property become less non-conforming because that makes it better. We recognize the septic is going to be improved. All that is a betterment to the property itself and to the surrounding neighbors. The issue for us is that our building inspector's saying they've lost the grandfatherness, if you will, of the old non-conforming. So when we have a letter too from Mr. Stewart that he had given to a previous attorney representing the Aherns that basically says, you narrow the house by a few feet, you elongate it, I'll give you a building permit now. And from my perspective, I don't understand why that didn't happen, and here we are insisting on the same footprint with the other changes instead of just getting it a little bit smaller, a little narrow, 3 feet narrower, I believe is what he had said. And he would have given you the Aherns the building permit at that time. So I guess how can you prove hardship on a variance when you could have had the building permit had you just modified the size of the house?
Sure. So there's a lot of answers to that. First of all,
Listen, if I had 3 lawyers in here, I'd have 23
right.
answers.
I don't even like listening to myself talk. I mean, you're not unique in that context. The reason why the status of the law is as I've suggested that it is because zoning boards, planning boards in New Hampshire, they don't have the authority to look at an application and say, but if this, and if that, and if this, and if that, because the board can never account for the individual reasons for why a proposal is what it is. That's why it has to take a proposal for what it is. Mr. Stewart's saying that no variance relief would be required if 3 feet were in. It's still not compliant with the Shoreline Protection District. That says that no structure can be within 150 feet of the water.
True that.
So if they tore it down and it's fitting inside 301 setback, it's still got a problem with the Shoreline Protection District. Practically speaking, this is a modular home. The Aherns have personal circumstances to include medical situations that require at least 2 bedrooms for just them. Then they add to the fact that they have parenting and significant responsibility for a grandchild that has to sleep a lot of time at the house. So all of a sudden, the subtext of the application starts to grow, right? Now they need a certain size house, and they want a modular house for a lot of reasons, one of them being the efficiency and the financial considerations for modular homes. Well, modular homes don't get customized a lot. They come in various platforms, and you pick the one that makes the most sense. That's the whole point of a modular home, right? It's not a custom build. So those are the types of considerations that are going into why what is being proposed. But ultimately, I don't think we can get away from the foundational point, which is the use of the property, which is what the state Supreme Court has focused on, is a single-family use, and people have the right to continue a single-family use.
I don't think anyone has even questioned that.
And
To be honest with you, the fact that it's a single-family use, nothing has changed. We're talking about the dimensional aspects of that building. We're not, neither Mr. Stewart nor anyone here, nor myself, have ever questioned the use. You're still asking for a single-family use.
Sure.
So that, I think that point is really moot. We recognize that. And we're not trying to deny the Aherns, or neither us nor Mr. Stewart, from rightful use of their property. In fact, we get accused of being too kind to the applicants, so.
I get accused of that too.
And that's not a bad thing, I don't think. But by the same token, our job is to uphold the regulations of the town while still affording the property owners the best possible use of their property accordingly.
Sure.
So, I don't know, I'd like to hear from my colleagues some more. I'm not sure how we're going to solve that particular issue, because does Mr. Stewart know that it's a modular home being proposed for that property? I didn't see it in anything I read, to be honest with you.
I think I think in the narrative we referenced it, and I can't speak to what Mr. Stewart knows or not,
Right.
but certainly.
It's not something you discuss with him.
I don't think
He
that's
does know.
something he.
It's not relevant in any ways. but-
Right, yeah, so I think that's, well, I think the point that we're dealing with is, did he make a mistake? And I think what plays for that is that he, and I think, certainly from Larry's and Ellie's comments, is that we've kind of been under the assumption that, because in your brief here you say that non-conforming uses may be continued, maintained, repaired, and improved, goes on to state, however, that non-conforming uses may not be expanded. And so I think that's what he's getting at, is that it's a small increase, but it's an expansion. And he further does say that you could fit that within this setback. And that's, I think, which is his key point. So he denied it because it's an expansion of a non-conforming use. Once as you said before, a lot of areas have this understanding is that once you take something down, it's a burns. If you take the existing structure down and decide you want to build a new house on a lot, you're looking at a blank lot and a series of zoning amendments. And the way to do that would be to go for a variance. And his belief was that, although it's not binding on us, is that variance would be difficult because if you could fit it on, especially using the same number of square feet on the property and maintain all the setbacks, then it would be hard to show.
So
basically, I'm trying to say that I would be reluctant to say that this administrative decision was incorrect because he's following the guidance that we've given him and the town has given him, and I think it's valid. So I think what I'm looking at personally is that I would tend to say no to that, if appeal the administrative decision, but then you could continue with the required variance requests, and we could treat those individually. I don't know.
How my other colleagues feel. In effect, what Peter's saying, that we should deny the appeal of the administrative decision because Robert is upholding our own regulations, and therefore, we should deny that and deal with the variances.
May I ask Peter a question?
Sure.
My stuff is in disarray, could be situation. I didn't bring my book. Peter, what you just read about expansion, is that state or our town regulations?
That's actually from the attorney's briefing sheet on the state law. That's statute 205.9. No, that's our statute, 205.9. And let me take a look at it right here. Non-conforming uses in existence prior to the enactment. It's the standard, what we refer to as grandfathering clause.
So that's state ordinance.
So this is a town ordinance that may be continued to maintain, repair, and improve, unless and until such use becomes an imminent hazard to the public. Obviously, that's not the case here. Health and safety. Non-conforming uses may not be expanded or changed to other non-conforming uses. This is obviously, it's not being changed to another non-conforming use. It's being expanded, the existing use, yeah.
And that's, so this is me playing lawyer, but this is a critical point. The state law, the state Supreme Court has looked at that exact question because that's what Seabrook did. Seabrook said, you are expanding a non-conforming use. And the state said, no, expansion of non-conforming use pertains only to the elements which are non-conforming. So you can't say that a house that is on a lot that is non-conforming as to a setback, but which is being expanded because there's going to be an addition on the back that's going to otherwise comply with the zoning ordinance, is being expanded. It is not, because the non-conforming part, the setback non-conformity, is not being expanded. And that's our whole point. That is the status of the law in New Hampshire. The setback non-conformity to the front lot line is not getting worse, it's getting better. The setback from the water is not getting worse, it's getting better. And that literally, you put your finger, Mr. Coffin, on the issue. Because I think that is what Mr. Stewart said, well, you're expanding it. We're not expanding it in the way New Hampshire defines expansion of non-conforming use, because we are not expanding the non-conformities.
The setbacks. You're
Yeah.
not expanding
Right.
the setbacks. The other thing is abandonment, and I know that you talked about the expansion of use versus abandonment, which is the tear down. We do have, as part B to that, it says no non-conforming use may be renewed after being discontinued for a period of 12 months or more. And so that would not apply in this case.
Are you still living there?
Yes.
Currently, yes. So it has not
no,
been
no, there's
abandoned.
not, no, I'm talking about if you tear it down,
And then
you're abandoning that use,
don't
then you
rebuild.
don't, and then you don't rebuild for a year. That wouldn't be legal. You'd have to go back to ground zero. You'd have to say, come in.
And that's the water saying they have to.
Yeah, and so.
So are you saying that as long as they build within the year, they would have a
The way I'm reading
continued
this
use?
is that non-conforming use may not be renewed after being discontinued for a period of 12 months or more. So I think what you're saying, the negative is of that is that it could be renewed.
Within the 12 months.
Within the 12 months,
months.
as long as it's completed within the 12
As
months.
long as we say that it's not an expansion of that non-conforming use. It's a new
But
building.
it is.
Well, I mean, yeah, and I see the expansion, as long as,
I still,
I think that the impervious coverage on that lot, which is 11.5%, on the new proposal, was, in the old house was 7.9%. They are within, that's not non-conforming because it's less than 15%. So, that wouldn't be an expansion of non-conforming use because it's conforming.
all right.
So, I see where you're going with this. I kind of wish we had something, but I think that from the point of questioning whether the administrative decision was correct, I think we've got to go based on what Robert based his response
His
on.
administration, his administrative decision was the
valid,
correct
and,
decision.
And that relief would be required from variances to proceed. So that's.
Have you got a drawing that shows the dimensions of what you want to put on the lot?
So every plan we've provided shows the dimensions. There's a plan set from Peter Landry, which is a state permitting plan set, which depicts the building as it exists today and as it's proposed. These big pre and post plans that we provided depict the whole lot
Copies here.
and the structure.
Yeah, I don't see the dimensions on it, Mike.
I don't, that's what I-
It's a scale,
I
and you
actually
can,
just saw them somewhere.
Right here?
Because I remember seeing the, yeah.
I see a scale, that's why I have a ruler.
yeah, those are all the setbacks or dimensions are there, but the house,
The
the
building, the size of the
If
building.
you look at, so right here,
pre-building, post-building.
it gives you, I don't know what.
Because the current building is, overall, including the deck, is 55 feet from the water side back. Or as you said, from the, across the front.
No, it's 25
Because-
feet.
Well, I'm looking at the assessor's sketch, and it has the dimensions on it,
Oh,
and it comes out to 55 feet in total, including the 16-foot deck. And then across the front, across the water side, it's 26 feet. Now, what I'm trying to do is compare those dimensions with what you want to erect. And I don't see those dimensions on, at least not on these.
not on these either, so,
I think, but it looks like they followed they really dealt with the setbacks from the boundaries on either side.
Right,
in a
right.
sense.
and I guess the other question that I was
Don't
about
tell
earlier,
me.
we didn't get an
I
answer,
don't know
and that is,
anything else.
will this structure be higher? Because that's, in this particular neighborhood, view is everything, and this is the closest to the lake, so, is it gonna be, and we know it's gonna be bigger, but is it gonna be
So it's
higher?
going to be 2 stories.
2 stories, and what's the current one, is it a story and a half?
It's a story and a half. Yes. So, I mean, our point is, it's less than 30 feet. That's what the maximum is.
Right,
And
yeah.
so it complies with the zoning ordinance.
Yeah.
Another thing I thought I would point out to the board, that this falls within the town's wetlands conservation district, and it's 2025B3, which I think relays the spirit and intent of this ordinance, and it really highlights what we're trying to say here. It basically says, where an existing building within the wetland buffer is destroyed or is in need of extensive repair, it may be rebuilt provided that such a rebuilding is completed within 2 years of the event causing destruction. The new or the rebuilt structure shall not extend further into the wetland buffer than the original footprint. And that's our whole, that regulation highlights what we're talking about. It doesn't say that it has to be completely compliant with the wetland setback. It says if your building is in disrepair and it's in the buffer or it's in the wetland, you can rebuild it as long as you're not pushing it further into the wetland buffer. And that really highlights our whole point. So it's like if the Aherns waited for their building to be dilapidated, they could, without getting a variance from the Wetland Conservation District ordinance, rebuild it as long as they were, as they're proposing, pushing it further to the water, which is nonsensical when you consider just the practicalities of that. It doesn't make sense, which is the spirit of what we're saying. That's why the law should favor real property rights. It's why it should favor the Aherns rebuilding in a way that's more consistent with what the town's legislative body has legislated in the zoning ordinance. I mean, it really captures what we're trying to say there.
I'd like a legal opinion, really. I'd like to know, and no disrespect, we have to
You're doing your job.
do our job, and I think we should submit this to the attorney and get an advisory ruling, something
Specifically,
on
what point?
what we have just been told, that the state law says that they should be able to rebuild, even though it's an expansion, and that the building inspector is incorrect in his turning it down.
Assessment. Building inspector's assessment was Mrs. Bond. Now he's stated, so you have 2 years to rebuild?
No, that's actually,
Well, no,
mostly
it's-
applies to, he's saying if they waited until it was dilapidated. So
Yeah.
that's for buildings that either burn down or, fall apart. You can put it up on the same footprint, so you still, 10 feet or whatever,
It's really, they would really fall, technically, I think they would fall in the 12-month timeline
Yeah, yeah. I
to
think-
have it completed within 12 months from the inception of the project, or the relief grant. It's up to you all. I have no objection to seeking counsel, in which case we'd have to continue the hearing.
If we decide that the appeal is denied, we would still be hearing, if we.
Well,
If we don't
we
take
can,
any
we can,
action, and the town attorney comes back and says, you have the correct information,
Oh, I see, and then you could.
then you can just overrule Robert and, they can go forward.
I don't know if you want to.
it's up to you all. I mean,
I
it's the simplest, and Mr. Passay is correct. If we overturn Robert's decision, then everything else becomes moot, basically.
Yeah.
However, I'm not.
I would like to have someone say that what we have believed in the past, which is that once you remove a structure, because we've had this happen in other areas.
It's not the first time it's
Right.
come
Not
up.
the
That
first
is
time it's
absolutely
happened.
correct. That is absolutely correct.
And we've, in the past, abided by that interpretation of the state law or whatever.
And the interpretation is, once you remove the building that's non-conforming and you want to replace it, you have to make it less non-conforming,
Well,
basically.
Which it is, which is
Or-
what this proposal is.
But it's
It's not
still.
totally
Okay,
or you
it's
have
not
to
totally.
make it conforming.
You have to make it conforming or less non-conforming.
I'm not sure about the second part of that. That's
Okay.
the question. So that's,
Right,
But to be clear, Madam Chair, the proposal is to make it less non-conforming.
except the size is bigger. You have more square footage. It's not,
There is.
it's not technically you're not replacing the existing. You are expanding the building, even though the footprint may not be different.
The aspects that are non-conforming are not getting any, they're getting less non-conforming, and the proposal otherwise complies with the zoning laws.
Yeah, and my colleagues are correct. We've had a number of instances. As I said, it's been over 20 years I've been doing this, and quite honestly, the intent is to make a piece of property that's not conforming in its existence prior to the regulations to come more in conformity, however slightly. The idea is to make it better, whether it be the septic or the size of the materials, whatever. You guys can make a motion and direct the chair to do accordingly.
I'll make that in the form of a motion.
Okay.
Second.
was the motion
Is to seek-
continue the,
Continue this and get a ruling, seeing if the statements made by the attorney say is accurate. And if it is, then we overrule Robert. And he'll know for the future.
Well, it may not be quite that simple, but I
Well-
can, yeah.
I would be more likely to request legal opinion where I felt that the town council was gonna have to defend our decision later, whereas,
Well, I'm gonna try and get Peter Laughlin out of retirement because he's, yeah.
obviously.
Good luck is what you're trying to say,
Yeah.
because I do call him, have called him a lot, not as much lately, let's put it that way. But he would be my guru if I had a choice, but. Okay, there's a motion on the floor to continue the hearing until we reach, so that we can have council review the proposal and our position thereto.
I second it.
Okay, and further discussion? All those in favor, please say aye.
Aye.
Opposed, say no. No, one no, and abstentions, none, okay. So it passes 4-1. So we will continue the hearing to our January meeting. Does anyone have a date so we can have a date certain?
I think it's the 13th. I looked at it today.
The second Thursday is the
Oh,
13th.
that's right.
It's
Because
seven.
we talked about, yeah.
It's 7:05, because you'll be the first hearing that night. And if I receive any written ruling from the attorney, Mr. Corsia, I will forward the same to you so that you can prepare for that next hearing.
I
okay?
appreciate that. I'm just gonna confirm that it is indeed the 13th here.
I believe so, because I think that's,
It's the way that the first falls on
We
a
both-
Saturday.
Okay. Yep, the
It's-
6th is the first Thursday and
The
the 13th
13th
is
would
the
be,
yeah, it says here the January 13th
Oh,
Okay.
on our little agenda.
okay, very good, thank you.
Thank you very much for your
and
time. We really
we'll-
appreciate it.
We'll
Thank
see you next month.
Have a
hopefully
Merry
live.
Christmas and a happy holiday.
We want
What?
have him review all of the,
I'm gonna have a look at the whole thing. We're not gonna do a piece, but because
we don't
other
have to-
things might be discussed, so, no, it has to be reviewed in its entirety. And if Peter is not willing to step into the fray,
Right,
we'll
well,
go accordingly for, let's see who he recommends. Okay, got here. Okay, and then 1 second.
Thank you again.
Thank you. Yep. All right, item next. Our next hearing is on CW Station LLC regarding Summit Distributing LLC tax map R40 Lot 15. The applicant, CW Station of Kingston, New Hampshire, seeks a rehearing on the decision by the Kingston Zoning Board of Adjustment granting to Summit Distributing LLC a special exception to the terms of Article 201, Section 4E14, to permit a retail fuel outlet within the Aquifer Protection District Zone B. Should a rehearing be granted, it will be held on January 13, 2022. We have a petitioner, Mr. Coombs. Please come on down. Greetings and welcome.
Hello, Phil Coombs, 6 Little River Road.
We would,
are you representing CW Station?
I am,
That's the name I have on here.
yeah. I am part
So-
owner of CW Station, the Coombs Farm, as most people know it, at 6 Little River Road. We requested a rehearing based on 2 points that the board was notified of, specifically improper notification, and then make sure I went in.
the second was whether or not we would give it a hydrogeological study or
Oh,
not.
no, it was whether we were,
Question the authority of the board to delegate to another board.
Oh, I
Yeah.
see, that's right, all right, sorry.
So I see that the original applicant sent a response. I don't know if you guys have copies of that. or
Yes,
not.
they do.
So if you'd like, I can just address these.
Yes, please do.
Okay.
You need to
So-
convince us why we should grant the rehearing.
Absolutely. So in the first one, my concern was that the Southeast Land Trust of New Hampshire was not notified of the hearing in the first place. They hold a conservation easement on the property, and I was actually shocked that they weren't notified of this. One of the documents that I have here is registered at the Rockingham County Registry of Deeds. It's book 5465, page 0723. This is the warranty conservation easement deed and deed restriction. The signatories to this are the Southeast Land Trust of New Hampshire and the town of Kingston, as well as the United States of America, specifically the U.S. Department of Agriculture. The town of Kingston is a signatory to this in an executory interest function. As such, this was signed in 2013 by the 3 selectmen. At the time, it was the 3 selectmen board. This specifically charges in the purpose section on page 2 and into page 3, the primary purposes of the conservation easement. And the section A is to protect the agricultural use and agricultural soils. Section B is the conservation and protection of open spaces. Section C is the protection of the water quality of the Little River, including the properties more than 3,000 feet of shoreline. So this is a document that the town entered into with the Southeast Land Trust of New Hampshire and the federal government, charging the Southeast Land Trust with protecting the water quality of the Little River, specifically on the property, but it does state the Little River total. That is where the proposed truck stop is going to be 500 feet from, is the Little River. So I don't see how the town can require someone to maintain the integrity of a waterway and then not notify them when a potential threat is being proposed directly abutting that property. I also think the case law that was cited by the applicant is from 1992. I would wager a guess that at that time, maybe 2% of the town's property was in conservation easements. At this point, I believe we're at 23 or 24%. The town has a vested interest in conserved properties because we have dedicated a lot of money to conserving property. And while the case law that was cited cites the minimum standard that the state requires, the town is fully within its purview to have stricter standards. And I would feel that it is an oversight on our part if we're entering into agreement with conservation easement holders and then not notifying them of potential threats to those conservation easements.
Is,
We're putting ourselves
can I
in
ask you a
jeopardy.
question?
Yep.
while I'm thinking of it? Where is it available in town for someone who files an application for a zoning variance? And they are told they have to notify abutters. Where in town would they find that type of information?
So this is in the property folder for any subject property that is in an easement. Additionally, on the tax card, I know for my property, I can't speak for others, but there is a notation on there that it is in a conservation easement. So that's all online. If you were doing a cursory search, I mean, it would take probably 5 minutes extra to look at the tax card and see if that was under a conservation
All right.
easement.
I just,
But to your point, I think the town should be making more of an effort to make that accessible to people who are applicants. So, but I think it's an oversight on the town's part to not be including easement holders.
So what you say, but what I hear you saying is that not every tax card has designated easement that may or may not be on that property.
I'm only speaking for my tax card. I don't know.
I understand that, but I'm also saying, to take that the next step, not every tax card denotes if there's any conservation easement on that property.
I don't know the answer to that.
Okay.
But my assertion is that the town has entered into other agreements, not just with the Southeast Land Trust, but also the federal government. And as the executory interest in there, we are responsible for making sure not only that the Southeast Land Trust is following these things, but should they fail to do them, we are responsible for carrying out these duties as well. So again, without notification, we're not allowing them to do the job that we're tasked with ensuring them to do. You know, as far as what they bring to the table, they have a lot more institutional knowledge of what this potential project, what potential downsides there are to the aquifer. And I think, you know, to put it on just an individual abutter to have to go out and learn about the fluid dynamics of fossil fuels in, you know, it's kind of a lot for me to take on, especially, you know, in a limited time frame. So that was the first part of it, and I don't know if you want to ask any questions on that or move to the next one.
Go to the next one, yeah.
Okay. The other one is, you know, in the ordinance, it charges, in the case of a special exemption being granted, the ZBA imposed, or that imposes additional protections for groundwater if it is to grant a special exemption. there are two problems here. One, as an independently elected board, you do not have the authority to dictate your responsibilities to another independently elected board. So if you were charged with imposing additional protections for groundwater, it cannot be handed off to the ZBA as it reads right now. And the other side of it is as the minutes read right now, it states,
The part that says it may be.
yes.
Yeah, I
So-
noticed that, instead of shall,
Yes, so may and shall is, they're miles apart. May is, if you want to, shall is you will. And essentially by saying may in those minutes, you have put no restrictions whatsoever on the applicant, whatsoever. And while I think we have a very competent planning board, unfortunately, they also have to worry about lighting, trees, you know, the flowers that everybody was worried about on an adjoining lot, or the traffic signals, all things that weren't really pertinent to the Aquifer Protection District, or Aquifer Protections, but those items, I could go on and on. I served on the planning board for over 2 years. There are a million things that need to be considered. Specifically, this board was charged with the aquifer protection aspect of that, and no protections whatsoever, as currently written into the minutes, were placed. It's whatever the state has out there right now is all that truck stop will be subject to. And I don't think that's a good idea. So those were our two contentions with how the process was done.
Okay. Before I open up to the board, I'm going to ask if there's anyone from the audience that would like to speak in support of the request for a rehearing. Mr. Russman? Sure, come on down.
Just to, for the record, my name is Rick Russman, and thank you for giving me an opportunity to speak. Just for the record, as part of doing the due diligence, sending out notices, it's really not that hard to find out who easement holders are, particularly, I mean, it's really not difficult to check tax cards and things of that nature, and to find out who is an easement holder. And the town did spend a lot of money on this piece of property, as it turned out, the 50/50 farm and ranch land, what they call farm and ranch land easement, with the feds kick in 50%.
You might want to speak up a little bit, Rick.
I'm sorry,
Yeah.
the feds kick in 50% of the cost, the farm and ranch land program, and the town kicks in the other 50%. So we do have a clear interest, the town does, in that respect, in water quality, because that's one of the things in the easement that the town spent money on. And what we have here is we have one of the, I think only 2 active farms in town asking for a rehearing. And I mean, this board, obviously, your constituents are the townspeople, so we have somebody, and to have another month go by and have a rehearing, it doesn't seem like it's a real heavy lift to do that. And grant a rehearing so that new evidence and other evidence could be, it's obviously an important matter, and certainly give Mr. Coombs and whoever else wants to speak on it the opportunity to be heard. So hopefully.
I bet judges had a hard time hearing you, too.
Oh, yeah, well, hopefully I'm sorry, I know the acoustics are just atrocious.
It's
here.
terrible here, so that's
Yeah.
why I try.
But hopefully, the board would grant a hearing, and like I say, I think a month for Summit Distributing LLC to wait is not a heavy lift for them to do. And certainly we give Mr. Coombs and others who was not been able to be at the original hearing an opportunity to be heard. So hopefully we can bring it.
And just to Mr. Russman's point, the conservation, and it wasn't made about this money, just for the record. The original owner, it was $282,500 that the town, I guess, spent half of that money to conserve the property. So just to put a dollar number on that.
Okay, thank you. Does anyone else like to speak in support of the request for rehearing? Okay, in opposition to the request for rehearing? Okay. Comments from my board?
Yeah, I'm kind of surprised not to have someone here in opposition to that request, although quite frankly.
Well, in fairness to Summit, they did call to see if they needed to be here, and I said I didn't think so.
Right, well, the
Because
only
they had
reason I was
pretty-
going to ask is that we kind of divide this into two parts. The first being failure to notify, and that is based on statute, New Hampshire 676(7), which says the appellant and every abutter and holder of conservation, preservation, or agricultural preservation restrictions shall, again, not the, it's mandatory, be notified of the hearing by verified mail and so forth. Then it also says that the board shall hear all abutters and holders of conservation easements, so forth. So we obviously, that notification didn't occur, and I would suggest that the easiest remedy is, since there is a remedy for that, is a rehearing. The second part of this, which is whether this board can require that restrictions be placed on this. I think that should be the case. Without going through the whole thing of getting escrow fund started and hydrogeologist and the town engineer to look at this and see what restrictions would need to be placed.
If any.
If any. Well,
Because I'm going to interrupt you there, and if we discussed that point at the hearing, whether other abutters were here or not, and the point was that the amount of water, and I don't remember the exact numbers, usually it's, let's say
So
it's
those for the
3,000
septic.
feet, and it was less than half of what would be required had there been.
right, but that wasn't the requirement for the gas station.
But
The gas station, permission for the gas station, which is prohibited in that zone,
well, it's not
required-
permitted, and it's a special
It's a
request,
special exception.
is required
It was
to
required
allow it.
to
So it's
allow
not
it.
prohibited.
It actually was, but, then it says you can get around that with a special exception. However, it's listed as prohibited. Be that as it may, which it does say, and this has nothing to do with the hydrogeologic study, that the ZBA is, I can't remember the exact wording, but it's required, but, or it says with restrictions. So, we had to kind of agree that, in order to avoid having to have us go through the process of complete engineering reviews and deciding what restrictions are going in, the planning board, we couldn't co-meet with the planning board because the application wouldn't be in front of the planning board yet, so they couldn't hear that. We would then take presumably the engineer's recommendations and DES's and put some restrictions in place. The only problem with that is then that those restrictions would be binding regardless of what else would go in, whatever the planning board decide. They can also put restrictions in during the planning process, the site plan review phase. I think we're trying to streamline the process and make it so that this whole engineering review would go on as it did with the warehouse project in the site review process, and that the restrictions would be put in by the planning board, the additional restrictions would be put in by the planning board. I think the advantage of going to a rehearing is that we could have time to get, again, a professional opinion from an attorney on whether or not we can delegate that, even if we change the wording to shall, or if not, whether we would need to hold, to have plans and have them sent to Dennis and go through the whole process of multiple meetings to do that. And quite frankly, where I'm going with this is, my opinion is that the failure to notify is sufficient to grant the rehearing, as a civil remedy. Then, in the rehearing, we can decide, and we'll have time to get an opinion on that, whether we would need to actually develop the restrictions in place.
I have said in previous meetings, this board is not equipped to
Yeah.
review a hydrogeological study.
And be that as it may, I just have to question
That
if,
But the reason, Phil, that the reason we did not require it was because the amount of water, that land is so dry in that front, it wasn't gonna be, they've done a lot of test pits, and the amount, I don't have the exact wording from the hearing before us. Let's say it's normally 3,000 feet, you need to have a hydrological study no matter what. And that was not the case in this situation.
the hydrologic study criteria was based on septic systems.
yeah, and say, you know,
that
if they're
was-
under the threshold for an organic material being leaked into the ground, that isn't gonna harm anything versus burying massive
Right.
tanks that have, you know, fossil fuels in them that can leach out.
However, you gave us.
But my point is
Let's
this,
not go
it can't
down
be
that.
decided in the middle of a meeting that it's beyond your capabilities to handle that. With the accessory dwelling units, that had to go to the voters, where that was, a large portion of that was shifted to the planning board and taken off of your plate because it was a more efficient process. And if the board feels in the future that, you know, more technical review is required, then the ordinance needs to be rewritten to reflect
And
that.
I agree with you there,
Yeah,
I don't
But
disagree
it
with
can't just
that.
be an audible in the middle of a meeting to pass it off to the planning board.
Well, it may still be passed off to the planning board if the rehearing is granted, quite honestly.
And that's where I would like, as Larry did in the other one, I would think that we should get an opinion of whether that's even legal, because if it's not, then they're gonna have to come in with an escrow account, and we're gonna have to develop a timeline to have the plans to Dennis, you know, a certain amount of time before the hearing and everything else, so, we're running short on time, so,
Well, that issue is moved. Depends, if we grant the rehearing, there's nothing to say that anything gets changed.
right, well, that's true, however, we'd like to have, I would like to have a position so that
Whether or not-
the town attorney is the one who's gonna have to defend this in Superior Court if that's where it goes. And so I would kind of like to have him say whether we're punting it down to the PB is legal or not. And,
Okay, we can.
and so I think that's something that we could decide. Basically what I'm saying is, I'm punting off on that decision to the rehearing, where they presumably can bring in their attorneys and say whether they think that is right or not. And the town can provide legal opinion on that.
I
But-
do think at a minimum, the rehearing should be granted based on this information.
Yeah, and I think we're ready to vote on that.
You can make a motion to that effect.
Yeah.
Go right ahead.
And I would make a motion to grant the rehearing.
Okay, is there a second?
I'll second that, yeah.
Okay, discussion on the granting the rehearing. And do you want to put in for since the conservation easement holder was not notified?
Yes.
Yeah, as a reason,
Yeah.
because, well,
And
actually, you said there are two easement holders that were not.
The other's the town of Kingston, I believe.
Correct.
Oh, okay, that's,
So that means that the petitioner would have to look up every single deed, every abutter's tax card to see if there is an easement on their property.
So to my
And if it's
knowledge-
not, on the tax card, oh well.
Well,
Or do
actually-
we have to send them to the Rockingham County Court? That's a big ask, because it's no longer a matter of coming to the town hall and getting your butter list. If they can't easily look it up on that tax card, that there's an conservation easement, now it could be that we never have a decision on the first or second or even third hearing, and that all deeds have to be researched at the county courthouse. That's a huge change
well, it's,
in what we're doing.
but it's not our law, it's state statute that requires that, and, it's not that hard.
You're not listening to me. I'm
Yeah.
saying, and Larry asked the question earlier. If it's on the tax card, that's one thing. That's not a big ask. to go through the tax card. You look at your butters list, you go through the tax card, and if there's a conservation easement, is it listed in all tax cards? And we don't know that answer.
I do think, so,
Actually,
again, speaking for my own property, you know, there are certain codes on the tax card with, you know, current use and things like that. There is a
Yeah.
conservation code. I think someone would probably be pretty stupid to not take advantage of it because it's even cheaper than current use, because you can't do anything with the property. It has no income potential
Yeah.
beyond just being a piece of land.
Okay.
So, if someone has an easement where this kind of thing is charged, because, you know, they're all in the hallway downstairs, all the conserved properties in the town
Yeah.
are down there.
Yeah.
They're of sizable enough size that people would be taking advantage of the tax benefit of that. Whoever the current owner is would be utilizing that tax advantage. Again, I can only speak for
Need
my.
to have a conservation easement on their property?
The conservation code that the
Oh, I
assessor
see, I
uses
see.
to, and again, I
Okay.
cannot speak for anybody else's card, but
You know it's
the
on
conservation rate that my land, the conserved portion of my land is taxed on
Yeah,
is at a lower rate than even current use.
okay,
So one of the advantages of putting your land in conservation is that it is taxed at a lower rate. So
okay.
I don't think this is that big of a pull for an applicant
Okay.
to look that up. But
You're making me feel better if that's the case. I just can't imagine all applicants having to go to the registry of deeds and looking up every deed and God knows how far back they have to go to find one. That, I think, is an undue burden on any applicant seeking the variance for anything.
But I think the town, with the significant portion of the town, nearly a quarter of the town is now under conservation easements. I think it would be a good idea for the town to make that readily accessible, so a trip to the registry is not required.
Right,
yeah, it's not just conservation easements, by the way, it's all holder of conservation, preservation, or agricultural preservation. Okay, so those are all pretty much the same, and I think we would.
I think at a minimum, the town needs to make it ones where they're charging another entity with enforcing, you know, water quality rights or, you know, certain aspects that can be affected by an abutter, then it would be incumbent on the town to make that information available. But that's, again, I can only speak to my tax card.
okay.
I guess if maybe Rick had the answer to it.
I was going to be,
Yeah.
thank you. Rick, did you want to add something? And you need to come up front and we need to project your voice a little bit. Thank you.
Yeah, I don't look at other people's tax card. My own does have the same thing, and I think conservation easements on my property, so.
I just want to avoid an undue hardship on any applicant.
Right, sure.
Because if we really are sending them to the county registry,
Right.
that's going to be unbearable.
Right, that shouldn't
Unfeasible.
happen because they-
Inexpedient to legislate, if you will.
Yeah, if they just go to the tax cards, it should be on.
It should be on the
it's
tax,
online as
okay,
well, so.
okay. So there's a motion on the floor to grant the rehearing because the conservation easement holder had not been notified. And
And
it's,
to notify them.
well,
Well, yeah,
that goes
that's-
without saying. We have to rehear,
Notice
what
of
will-
rehearing, we'd have to.
what will happen is we'll have to reissue the abutters notices and include Southeast Land Trust.
Yes. And Town of Kingston is. they want-
Town of Kingston, if there's two conservation easements, one's in Southeast Land Trust name, one's in Town of Kingston's, both will have to be notified.
And you just, the federal government as well, Department of Agriculture.
Or they just
They
enforce
have,
them?
no, I don't think, they don't have an easement on the property.
They are third party, they have a third party enforcement right. So if it comes, the way it was explained to me is basically if the Southeast Land Trust is not enforcing the easement and the town of Kingston is not enforcing the easement, then the feds come in and kick heads. But that's it's a
So you're
third
saying
party
it's-
enforcement right, so it's highly unlikely to happen.
So it's not,
The 2 of the 3 is okay, is what you're saying, Phil? I want it clear, because I don't want to have you come back another month from now and say, no, you didn't do it right. No.
You have
Now's a
one
chance.
easement, and the easement holder is Southeast Land Trust?
One
Is that
conservation easement?
So, with warranty covenants, the conservation in perpetuity to the Southeast Land Trust. So they are the primary holder or
Okay.
enforcement authority.
For both the town and the.
Correct.
But they're the owner of the
Okay.
easement. Yes.
So they're the only ones that need to be added to the abutter list. I want to be clear, I'm not trying to be difficult.
In my personal opinion,
Yeah,
they are the ones who are directly charged with the water quality aspect of the easement. So
Okay.
it would be incumbent on them to be aware of a
Okay.
potential situation.
I just want to, I don't, if it's 3, tell me now 3. If it's 1, we'll just go southeast
I
line.
think it'd be a waste of a stamp to send it to the feds.
Never mind the town of Kingston, because we're 2/5 of it. Okay, so we have a motion on the floor.
Okay. And we're still doing the discussion. I just wanted to point out that in the rebuttal, CWS cites this is from the attorneys for can't remember the name of it. Summit, thank you. They said that CWS cites no statutory authority supporting its contention that the holders of the restrictions were entitled to receive it, and the S in RSA stands for statutes, and you know, that's pretty much a false statement, since it's given right here that the state requires that, and they made it very clear that it's mandatory. So that's the response to that rebuttal.
Okay.
So, but that was the only other comment I wanted to make sure that put in.
That you were heard, okay, I got it. All right, ready for the vote, gentlemen and ladies? All those in favor of granting the rehearing, please say aye.
Aye.
Opposed, say no. Abstentions? Ayes have it. Hearing in just January. So you will get another notification accordingly, as will the other butters
Thank you very
listed.
much.
Okay, any other business to come before us this evening? Then we are adjourned at 8:26.